position of the arbiter is to address the overall relationship between employer and union, because by the time a grievance gets to him, an honest grievance which the union thinks is real and tangible, then the problem is probably not that individual grievance, but the relationship.
In my experience in the auto workers, and now I'm speaking now in the 40s, the auto workers union resorted very often to direct action. In other words, they'd shut down the line. One of the stewards would just trip the switch and wait, and the foreman would come like angry hornets out of their nests and want to know what's going on, and then they'd be confronted with the issue.
The employer has the right to do with his employees and his property as he likes, subject only to what the employees have been able to win away by contracting specifically. And that's what most grievance arbitration is about. What specifically did the workers win at the table? That's why there is so much wordplay about what the word meant and what the practice was.
To solve a workplace grievance, I think first of all we have to understand what a grievance is. If I walk into the plant tomorrow morning and I see something happening, doesn't mean that I have a grievance. I mean, a grievance has to be something related to the collective agreement. You have a grievance if the collective agreement is violated. You have a grievance if you feel the company was unjust in its power as managing the company.
Yeah, the best way to resolve a grievance, in my view, is if you have an employer who respects the role of the union and respects the role of the workers in the workplace. If that exists, you can usually resolve them informally in a third-step grievance meeting. You get the parties around the table, talk about the issues, argue it out, have the worker there, have the union steward there, and argue it out.
Grievance arbitration is like most things, a little bit of good and a lot of bad. It allows workers to say that an employer has exceeded what he's won at the collective bargaining table, that he's exceeded his rights and under the collective agreement, and he can't just simply throw out a worker who has refused to obey a command.
Insubordination, I mean, the big problem there is defining the point where you're saying a person is really just standing up for himself or herself and making a reasonable statement, and when it becomes abusive. I mean, I don't think you just have every order that has to be followed, jumped to by the member of the bargaining unit. It depends on what's abuse in terms of what the milieu is. I mean, if you're down in the bottom of a mine, for example, certain types of profanity, I mean, every other word's going to be the F word. I mean, it's just inevitable that that's the situation. That might be looked at completely differently than if you were in an office and you began to rant and rave in the same way.
Grievance arbitration has various defects. Perhaps the most serious from a union point of view is the delay that seems to be endemic in the process. One case I had went on for 3 years, if you can believe it. And by that time, the people who had been involved in the original dispute were either dead or long gone. The
delays are frustrating when you are going to arbitration. I had a case one time, a couple of years ago, where the employer hired a lawyer who's classic at delaying. We ended up having a hearing that should have gone on for maybe 2 days, last 4 days, which ended up costing a huge amount of money. For a day of arbitration hearing, let's see, the arbitrator usually charges around what is it, $2,000 to $2,500 per day, and then we split the union and the company have to split the cost, so you're talking at least $1,000 a day for the arbitrator, plus the room booking you have to pay, plus if you're using a lawyer, we're not supposed to talk about lawyers' fees probably, but lawyers' fees are a lot too, so you're talking at least another $1,500 for your lawyer for the day, so you're talking $2,500 to $3,000 per day for a hearing. So if you drag it from 2 to 4, you're going from $6,000 to $12,000 for just the union's costs. It's a lot of money. It's a very expensive process. So I find it hard to spend that kind of money. But, that's what we're there for, and sometimes we have to.
You think arbitration's expensive, and it is. But, it's nothing like going to the courts. If you go to the courts now, the costs are, just horrendous. You get a bill for $25,000 for your material that has to be disseminated amongst the parties. That's not even the lawyer's time. You see, some of the costs are huge.
We'll be in an arbitration resolving a problem that may be have an adverse effect on an entire workforce of 400 or 500 people, and we'll be sitting there fighting out this legal battle with the company counsel in a room in which perhaps 3 or 4 people from that entire bargaining unit are there. The rest of them don't see what's going on. They hear a result which may be 2 or 3 months down the line. And it's not at all uncommon in arbitration to say, well, you remember that problem we had about 9 months ago? Well, we finally got resolution. It only cost us $10,000 to solve this $300 problem. It's a huge drain on the financial resources of an organization, which then aren't available for whether it's education or mobilization or buying hot dogs for a kid's picnic. But the more devastating effect is that it tends to bureaucratize the organization and minimize the importance of rank and file activity. And that's far more devastating than the dollars spent in the process.
Grievance arbitrations are costly, and they're held in hotel rooms long way away from the factory floor. That's disempowering and non-participatory. If you think about the capital-labor relationship, workers, when they enter into a contract with the employer, they actually sell themselves. What they're selling is their ability, their capacity, their intelligence, their emotion, their dexterity for a certain number of hours. The collective bargaining process, about how much of themselves are they actually selling for how much time. And that's what each contract is. The problem for the employer is that having bought a person for a limited amount of time on certain conditions, he cannot guarantee for himself that he can get the right amount of work out of that employee. So what he needs is the help of the law. How does he get help from the law? Well, the law implies into every contract of employment a duty to obey, and a duty of skill and care, and a duty of loyalty by the employee, not by the employer, by the employee. Now, of course, that enables the employer to discipline, and that's the word that we use, the employee, and that's how you can extract the work, the amount of work that you've bought, and that's how the law goes about doing this.
I have difficulty answering that question in this way. My problem when you talk of labor and capital, that's an ideological model, and I'm a pragmatist. I'm a practical person. I'm actually out there representing employers in industrial relations situations, and believe it or not, I don't have that much to do with, quote, the capitalists. I have quite a lot to do with the industrial relations professional. And the decisions they make on the whole are based on professional management decisions. What makes sense in a practical terms? Can we afford this demand? Can we not? How do we do layoffs? People would like to think that it's a great fight between capital and labor. What I find is it's very often a pragmatic view from management side of how it should operate. But I've always had difficulty trying to fit this into a philosophic mold.
The prerogative of management is just simply the private property owning right of management, subject to whatever contract he made. Prerogative, by the way, as a word, means the rights of kings and gods. And the employer, therefore, in collective bargaining, is acknowledged to exercise the right of a king or a god. And that's what that is. Sometimes it's more politely called a residual management clause.
I feel more nervous doing an arbitration hearing myself than I used to. But if you're facing a lawyer on the other side, that's where I feel uncomfortable in doing a hearing, not being a lawyer myself, because they start trying to use technicalities on you, and you're not as familiar with them, and you don't have all the sort of the legal research behind you to prepare. So it then makes you have to use a lawyer too in order to provide the kind of the best possible defense. So, yeah, the more companies use lawyers, the more unions use lawyers, I think, for this process. And then it does become more legalistic, more expensive, more based on technicalities. It's not necessarily a constructive thing to resolving disputes.
The procedures and the so-called law which surrounds grievance arbitration is just as thick and sophisticated as procedures and rules which surround the normal legal adjudication system.
Always has been too many legal aspects in the grievance to arbitration. Objections over objections by companies and sometimes by unions also. Interpretations, the language that is used by legal people around in an arbitration case. But we always forget that the worker, the man or the woman that we're representing, they're not used to that. They walk there in the morning at the arbitration hearing. They see an arbitrator that acts like a judge sitting in front of them. They see a battery of lawyers on the company side. They see some lawyers or staff representatives on the union side. Then there's a bunch of objections that are presented to the arbitrator before the real hearing starts. The poor worker doesn't even know what the hell's going on. I had an arbitration case once we were there for about 2 hours arguing on an objection. When we walked out of there, the worker asked me, did I win my case or did I lose? The hearing didn't even go on.
The issue of grievance arbitration in Canada, I think, is very interesting. I think we, on the whole, for a long period of time, we had a very successful grievance arbitration. For instance, in the United States, they don't have mandatory grievance arbitration. It's one of the fundamental distinctions. We have compulsory grievance arbitration because we have no right to strike during the collective agreement. I think that's a fair quid pro quo.
An arbitral process was set up by the man who was to become a justice of the Supreme Court of Canada, Rand. And Rand was actually instructed by the Minister of Labor at the time as to what he should aim for. And what they got was what we now call the dues check-off, whereby unions can get the employer to check off automatically the dues due to the union. This, of course, helps trade unions a great deal because it's very difficult to go out and hassle your members for dues every week. Rand was very clear in what he was doing when he granted the dues check-off to trade unions. He said that means that trade unions, of course, were to become responsible trade unions. And he stated that very clearly, by which he meant that they were to make sure that their members did not act illegally during the life of a collective agreement. There were to be no wildcat strikes, that dispute settlement mechanisms should be abided by, and that the union should control this. In other words, without using that language, Rand was creating what social scientists call the trade union as a manager of discontent, as a pipeline through which the employer could exercise prerogative, but not directly. The union would help discipline its own workforce. And that, in fact, I believe, is what has happened.
Now, it happens in a lot of circumstances where a lot of our members in our union and other unions also feel that enough is enough, and sometimes they walk off the job. There was a walkout of a job in one of our locals there in Quebec that have occurred. Now, should workers have the authority to do it? I mean, that's a very good question. I'd like us to have the authority to do it, and I'd like us to have the legal way to do it. I think we would solve a lot of problems.
I don't see any end to grievance arbitration in the immediate future, but who knows? It may become more the case that you have arbitration because people can't afford the courts, and you're always going to have problems as long as you have employment relationships.
It depends of how human relations and labor relations are alive in the plant site. I mean, if it's a dogfight going on there between the union and the company, or between the company and the union, I mean, the grievances are very hard to settle.
Every union's different. They have different collective agreement provisions for a grievance procedure, but typically when we talk about a third step meeting, that's just the last step before you go to arbitration, before it becomes formalized in a hearing. And typically it's a meeting with the fairly high-level management person.
First step is a verbal grievance. And I think that there's probably chances by a verbal grievance that the foreman or the first level of supervision can probably have the authority to, will probably solve it. Once it gets to a written grievance, then it goes to a further step. And once it gets higher and higher and higher, it gets more difficult and more difficult to solve. Because the second guy, though, doesn't want to be too bad against the first line supervisor, and the third line supervisor, if the second line supervisor refuses it, and then, I mean, that's a lot of companies have that process, which is a very bad process in my view. Because, I mean, the more steps you have to go to solve a problem, the more that you're taking the chance that the problem is amplifying itself and enlarging itself.
Whether you can resolve grievances at the third step depends a lot on the relationship you have, depends a lot on what the case is, and whether the company feels that they're going to lose at arbitration or not. And yes, sometimes it means the higher up management person having to overrule a lower level supervisor. And so often when you resolve something in the third step, you know, we use words like, oh, this is settled without precedent, da-da-da-da-da, you know, for the company position that the company's taken. And in that way they feel that they can, you know, save face somewhat, and we can get what we want, which is the grievance settled.
I find is the best procedure is a very rapid procedure where you don't let the things drag. And if it can be a streamline where it is really dealt with and there's a solution to the problem.
We have in Ontario, I can't say about the other provinces, is we have a system of expedited arbitration under the Labour Relations Act, where if a trade union wants to have a quick hearing date, they can apply to the Ministry of Labour under what's Section 49 of our Labour Relations Act, and 3 weeks from the date of the application, the ministry appoints an arbitrator and the arbitration hearing takes place. So you get an arbitration hearing within 21 days of when you file. So the advantage of the system is that it's quick. The disadvantage of the system, of course, is it's really a roulette game. I won't say Russian roulette, but it's a roulette game, and it's just the luck of the draw who your arbitrator happens to be.
There's a continuous attempt to tinker with it, to expedite the arbitration and to make the writing of awards by arbitrators more quickly responsive to the needs of the parties, to make it less costly. But in fact, in my view, this will always fail. As long as you get lawyers involved, as long as you get parties who are highly paid involved, there are built-in structures which lead towards delays and cost and high technicality. The high technicality itself imposes a tremendous cost on workers because it is intimidating, and it means that workers feel that they cannot participate directly in the grievance process once it goes above the first 3 steps. At this stage, they will always call on union reps and or lawyers to help them out. Then the cost increases, the time increases, and the participation of the workers decreases. And that will always be so, no matter how much we tinker with it. I don't think there's any question what workers ought to have. They ought to have the right to strike if there is no grievance process. Now that's very costly, and people don't want to strike over everything all the time, every time there is a little dispute. But the fact is that the employer can't afford strikes either, just as the employees can't afford strikes.
We have here a court injunction which I want to read. In the Supreme Court of Newfoundland Trial Division, between Her Majesty Attorney General for Newfoundland, who's the applicant, and Newfoundland Association of Public Employees.
I believe if we ever bring that up, or if it's ever brought up by politicians in any government of the province, including the federal, I think it would be a big war. Corporate would fight it, politicians would fight it, but I mean, I don't think I'll see that in my lifetime in Canada, but I'd like to see it.
Because of the anti-union environment that we're in, yeah, there's more oppression in the workplace because employers feel that they're feeling more powerful than they did. Every set of negotiations, we're threatening strike action, we're doing all kinds of stuff on the floor. You can't just sit and resolve it. So because of that, yeah, you tend to see employers are trying to lower down wages and working conditions, and so you have to put pressure on companies to get them to do that.
I think part of the reason that shop floor situations are intractable and difficult to solve is that employers have not accepted the legitimate role of the union. And I don't think that the central battle about that relationship should be fought within the grievance procedure. I think the long-term future of labor relations involves unions becoming much more part of the power structure of the country. Labor is not another protest group. It is not trying to draw attention to the blood scandal or anything. Labor is there permanently, and even if it is denied free access or total access to the power structure of the country, it possesses power. And occasionally it needs to use that power.